You heard about the executive order. You have been reading about banks screening immigrants. And right now, you are wondering whether the account you have spent years building could disappear because of a headline. Here's what you need to know before you do anything. The provision that would have required banks to check immigration status at account opening was removed from the order before it was signed. Banks are not legally required to demand your papers at the door right now. But the order that did pass is designed to cause maximum harm through minimum resistance. The mechanism is not a mandate, it is a signal, and federal bank regulators do not need a new statute to act on it. In the next 9 minutes, I'm going to break down what the order actually does, the mechanism already moving against ITIN accounts without any formal rule, and the one mistake people are making right now that will be harder to undo than anything written in the order itself. On May 19, 2026, President Trump signed an executive order called Restoring Integrity to America's Financial System. The order directs the Treasury Department to revise the regulations implementing the Bank Secrecy Act, which is the federal law that governs how banks monitor and report financial transactions. This specific instruction inside this order is to look for signs that people without legal immigration status are opening bank accounts, taking out loans, or applying for credit cards. And it goes further than that. The order instructs the Consumer Financial Protection Bureau to consider clarifying that the risk of deportation and loss of income is a legitimate factor in evaluating a borrower's ability to repay. That is a formal signal to every lender in this country. Treat immigration status as a credit risk factor. The entire federal financial oversight system is now operating under that framing. Let me tell you what this order does not do, because this matters and a lot of people are getting the wrong message. The original version of this proposal would have required banks to collect proof of citizenship or immigration status from customers before opening an account. That requirement is not in this final order. They pulled back from it. Banks are not currently required to demand those documents at the door. But here is where the dangerous misunderstanding comes in. They backed down from the hard requirement is not the same thing as you are safe. The gap between those two statements is where real harm is happening right now to real families. And I need you to understand the mechanism, because this is how the Trump administration has learned to do maximum damage without triggering an immediate legal fight. Federal bank regulators have enormous power over how banks operate. They conduct examinations, they review lending portfolios, they rate banks on their compliance programs. They can signal, without passing a new rule, exactly what behaviors they expect banks to avoid. When a federal regulator walks into a bank under this new guidance and says, "Show me the accounts opened with ITINs, walk me through your loans to customers who lack a social security number," banks respond. Not because a specific statute requires them to, but because compliance departments exist to avoid exactly that scrutiny. Because a loan officer who just sat through a training on immigration status credit risk is going to make different decisions at the underwriting stage. Because a bank that gets flagged during examination for having a large ITIN account portfolio is going to think very hard about how it reduces that exposure. The chilling effect is the mechanism. You do not need a hard mandate for a chilling effect to destroy someone's financial life. This is how it works, and this is why the partial retreat from the original proposal is not actually reassuring. The National Consumer Law Center, one of the most respected consumer advocacy organizations in this country, put it plainly within days of this order being signed. People must not be denied mortgages based on assumptions about their legal status. They said that publicly because they already know what is coming. They are already watching, they're already preparing. Now, let me talk about who is most directly at risk from this order, because this is not an abstract concern for some future date. If you have an ITIN account, you are in the direct crosshairs. The individual taxpayer identification number exists for a very specific reason. It allows people who cannot get a social security number to participate in the legal financial system, to pay taxes, to build credit history, to send money, to pay rent, to do every normal financial thing that makes a life work. Millions of immigrants have used ITIN accounts for years. This order specifically flagged ITIN accounts as an area of regulatory scrutiny. Your account did not change overnight, but the regulatory environment surrounding it did, and that distinction is not abstract. That is the difference between a bank that was comfortable with your account last month and a compliance department that is now having a different conversation around its ITIN portfolio. If you have a loan application in process right now, a mortgage you are waiting to close, a car loan, or a small business credit line being underwritten, this is urgent. Lenders make decisions inside a window. If an underwriter operating under new financial federal guidance that frames immigration status as a credit risk variable pulls back on your application before it closes, you may not get a second chance at the same term. The time to get legal counsel is before that decision is made, not after you receive a denial letter. If you regularly send remittances, regular money transfers to a family abroad, those transactions are already being examined under the Bank Secrecy Act. This order explicitly instructs regulators to use that same law as one of the tools for identifying undocumented account holders. That does not mean you have to stop sending money home, but you should understand that your transaction patterns are now more closely scrutinized category of activity under this new regulatory framework. So what do you actually do right now? The first thing, and I want to be as direct as I possibly can about this, do not close your bank account. I know the instinct. You hear the news and the immediate response is to pull your money out, go to the cash, and disappear from the system. Do not do that. A sudden account closure, especially when involving a large withdrawal, can trigger a suspicious activity flag, and banks are required to report certain patterns of activity to federal regulators. A panicked exit from the financial system can actually look worse on paper than staying in it. A 6-year account with a steady record of legitimate transactions is not your enemy right now. Closing it abruptly is a bigger risk than keeping it open. What you should do instead is document your account history now while you can access it without any pressure. Pull your statements. Save records of your deposits, your payment history, your regular transactions. Print them out here or back them up somewhere outside the bank's own system. If anyone ever tries to characterize your financial activity as suspicious or irregular, that documentation becomes your evidence. A 6-year paper trail of normal, legitimate financial behavior is something you can hold up, and you want to have it ready. Second, if you have any pending financial transaction, a mortgage, a loan, a credit application of any kind, talk to an immigration attorney before it closes. The intersection of your immigration status and your financial transactions is not a simple calculation right now. The right legal advice before a decision is made can change what happens. Waiting until after a denial to call an attorney is almost always too late. Get in front of it. Third, I need you to stop letting the partial retreat from the original proposal fool you into thinking the danger has passed. They did not implement the hardest version of this policy, but the order is in effect today. Regulators have their new guidance today. Bank compliance departments are having internal conversations about this right now. The pressure on ITIN account holders is building right now, not at some future date when a harder rule might eventually get passed. Here is another thing I want you to know, and I mean this seriously. This order is going to be challenged in court, and there are real existing legal tools to fight it. Banks already operate under federal fair lending law. That law prohibits discrimination on credit decisions based on protected characteristics. It does not contain an immigration status exception. It does not say that the federal government can instruct banks to treat undocumented customers as credit risks and that fair lending laws simply does not apply. Consumer advocates and civil rights attorneys across the country are tracking every loan denial, every account closure, every refusal that flows from this order. If a bank denies a mortgage based on assumptions about someone's immigration status, that denial can be challenged. Legal organizations are already building those cases. The executive branch issues orders. Courts interpret whether those orders violate existing law. That process takes time, and real people will face real harm in the meantime. I will not pretend otherwise. I have watched enforcement waves come through this community before. The harm is not hypothetical, but the legal architecture to push back exists, and it already is being mobilized. What I need you to take away from this video is simple. Stay calm. Do not make panic decisions that create problems you do not currently have. Protect your documentation now. If you have a specific financial situation in play, a loan, a mortgage, a pending transaction, get legal advice before something closes. And if your account gets flagged or your application gets denied in a way that feels like it has something to do with your immigration status, do not accept that as a final answer. Talk to an attorney. Those decisions can be challenged. This is a breaking situation. It will continue to develop. I will be covering it here as it moves through the courts and as we see how banks actually respond on the ground. Subscribe so you do not miss those updates. If this is affecting you directly, our team is at Lincoln-Goldfinch.com. We work with immigrant families on exactly these situations every day. And if you want to understand what your rights actually are the next time you have any interaction with federal authorities, watch this video right here, because knowing what you can and cannot be required to do is the most important thing you can have before any of this gets closer to your door.